The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. This morning we have two cases for submission. The first is Ommen and Wiggins versus MilliMan, Inc. The second one is Dickey versus Iowa Ethics and Campaign Disclosure Board. The second case is to be submitted non-oral, so it is deemed submitted at this time, and we're ready for the arguments in Ommen versus MilliMan. Who's up, Mr. Locher?
May it please the Court, Steve Locher on behalf of the Appellants MilliMan, Inc., Kimberly Hymans, and Michael Sturm. The liquidators of Co-Opportunity Health, an insolvent health insurance cooperative, brought common law claims against my clients for damages for professional malpractice and under related theories. We moved to compel arbitration under the Federal Arbitration Act in light of a broad arbitration agreement between MilliMan and Co-Opportunity that applies to any disputes that arise out of or relate to the engagement of MilliMan by Co-Opportunity.
The claim's not a contractual claim that they brought, I don't think, is it?
They have intentionally avoided bringing a breach of contract claim, that's true, but the case law is very clear under the Federal Arbitration Act that you can't artfully plead your way around an arbitration obligation by bringing contract claims rather than tort claims.
But for instance, in legal malpractice claim, something that many of us have thought about at least, there's a contractual claim. You know, you have a contract with your client, the engagement letter comes out, and law firms have worked on engagement letters to protect their interests and so forth. But aside from the engagement letter, there's also an underlying tort claim. Statute of limitations can be different and other procedural differences. So it's not, I mean, the trouble I have with your argument, I mean, I understand it, of course, but the tort claim is independent of the contract claim. If there was no contract at all, the tort claim would still be there. So I'm not 100% sure. I'm having trouble. I mean, I understand they're related and they overlap and all this kind of stuff, but the tort claim strikes me as an independent claim. So why don't you address?
Sure, and I'll do it a couple of ways. First, I respectfully disagree with the premise of your question. I do not think the tort claim is independent of the contract claim, because if there was no engagement contract here, MilliMan wouldn't have done any work. So the liquidators would not have any claims, period, whether sounding in tort or contract or anything else. In terms of the precedent under the Federal Arbitration Act, though, that doesn't even matter, because what the U.S. Supreme Court and other lower courts have consistently held is that if you've got a dispute that even touches upon matters that are identified in the arbitration agreement, then those disputes have to go to arbitration. And so in Southland Corp versus Keating, for example, the plaintiff tried to bring a statutory claim instead of a breach of contract claim. U.S. Supreme Court said it didn't matter. It still had to go to arbitration.
Maybe with respect to signatures, but here you have a non-signature, and the presumption is against arbitrability usually with a non-signature, isn't it?
There is no presumption against arbitration under the Federal Arbitration Act or, to my knowledge, Iowa law with respect to non-signatories. And instead, non-signatories are routinely held to be bound to arbitration agreements. And that's reflected in a number of federal court cases that we've cited, federal appellate court cases, specifically involving claims by insurance liquidators against third parties for damages. Those cases include Bennett and Quackenbush from the Ninth Circuit, Souter and Grody from the Third Circuit. The liquidators in those cases had not signed the arbitration agreement, and yet they were still bound by it when they brought claims that belonged to the estate against those third parties. The same thing is true. Let me take a step back. Iowa is one of 4 states where insurance liquidators have brought claims specifically against MilliMan. In the other 3 states, Kentucky and Nevada and Louisiana, the liquidators in those cases did not sign the arbitration agreements, and yet courts in all 3 states have held that the liquidators had to arbitrate their claims. And this court's precedent is fully in accord with that. If you look at Bullis versus Bear Stearns or Roth versus Evangelical Lutheran, this court held that non-signatories to an arbitration agreement were in fact bound by that arbitration agreement when they brought claims that fell within the scope of it. So we disagree with the district court's use of this non-signatory distinction as somehow having any significance here.
What do you make of the liquidator, I'll call it the liquidator statute. That's kind of a loose term, but number one, the insurance commissioner is a liquidator. Number two, it talks about broad public policy and protecting not simply the assets of the now defunct organization, but creditors and policyholders and the public. And so the argument has been made by your opposing counsel that, well, you know, the legislature has chosen this public officer to be liquidator under a statute that talks about public policy. Given that liquidator, I think, muscular powers. I mean, you read through it and you kind of, oh, really? I mean, you know, a power to disavow contracts. I mean, this liquidator is the green giant, and so challenge my characterization. I mean, if I'm not right on what I'm saying, please correct me. But it looks like we've got a very muscular liquidator who is directed to protect the public. And that's not quite the same as, you know, the ordinary bankruptcy trustee that, you know, gets appointed in a liquidation. Respond, please.
Sure. So let me start with this. There are two different cases that in some respects we're bouncing back and forth between from this court's precedent. One is Rent-A-Center, which is what the liquidators are trying to analogize this to when they talk about their public protection role. The other case, which we believe is much more squarely on point, is Roth versus Evangelical Lutheran, which involved the administrator of a decedent's estate. The key difference between those cases isn't who was serving in a public protection role or who wasn't. The key difference is who the claims belonged to that the liquidator or administrator was trying to bring. If the claims belong to a party to an arbitration agreement, it doesn't matter what public protection role the liquidator might have, they still have to arbitrate those claims. By contrast, if the liquidators had their own claims, which they don't here, not in this context against MilliMan, if they did, then they might have an argument that Rent-A-Center would apply, but they don't. In Rent-A-Center, the Iowa Civil Rights Commission always had its own claims separate and apart from any claims that any aggrieved employee had. And that's why this court concluded that the ICRC wasn't bound by an arbitration agreement. It didn't have to do with the public protection role. It had to do with whose claims they were bringing.
Well, let me ask you this. I mean, if you look at the contract here, I mean, it's an interesting contract. I will say that. It's interesting when you have the caps on damages. You know, it looks a little one-sided, at least in terms of some of the remedies that are available against Milligan. And in fact, if one were a little bit cynical, one might say it's kind of an inside job. It looks really kind of unbalanced, and of course, the liquidators decided to disavow the contract. So, isn't one of the reasons why we have the statutory structure just to avoid kind of inside baseball that leads to, I mean, kind of disastrous results like we have in this case?
Well, let me respond in a couple of ways. First of all, the Federal Arbitration Act precedent is clear that whatever state policy might underlie the enactment of a state statute, as soon as that state statute impairs somebody's arbitration rights, it's preempted, it's unlawful, and it doesn't have to and shouldn't be followed. But there's a different question there involving the disavowal power. And we respectfully disagree that the liquidators are really disavowing anything here. I understand they're using that word, but in our view, it's just another example of artful pleading.
Well, wait a minute, though. They don't want 3 times. They don't want that cap on damages that was negotiated in the contract. They say that's ridiculous. We want consequential damages and whatever we can prove. Now, maybe they can prove nothing, but it seems to me the liquidator's position is that this contract was not in the public interest and was detrimental to policyholders and has made a public policy judgment, I guess, right or wrong. So,
Right, but here's the issue. On the one hand, their claims against MilliMan are based entirely on alleged deficiencies in work that MilliMan performed pursuant to that contract. And when you look at the substance of their claims, I would submit that it's impossible to reconcile that substance, which is entirely based on the contract, with the idea that they're somehow also disavowing that contract. Those two things, I would submit, cannot work in harmony with one another. And in fact, when this court is deciding what the scope of the disavowal power is, one of the principles that it should follow is a principle that it recognized in Roth, which is we should try to avoid interpreting a state statute in a way that creates a conflict.
I mean, are you saying, like, I'm someone familiar with bankruptcy law, so it's like assume or reject. If the trustee rejects the contract, it's not like the contract never existed, that you can, or that you can just pick and choose which provisions existed. And what it means is that then the other party of the contract has an unsecured claim against the estate.
Exactly. That is exactly the right principle that should be applied here.
Is there anything about the arbitration forum that would handicap the liquidator's ability to conduct an orderly dissolution?
No, they can bring the same claims in arbitration that they want to bring in district court, and that was exactly the basis for a number of federal appellate courts that have concluded that there's nothing wrong, there's no inconsistency between the Federal Arbitration Act and state liquidation laws. There's no impairment of the business of insurance, there's no intrusion on a state interest. So the liquidators can, in fact, bring all the same substantive claims there that they can here, which is another reason why the federal appellate court cases have come out the way they did. And I really want to emphasize...
What about the confidentiality provision, though? Is it less transparent? Is the public kind of kept in the dark?
Well, that gets into some of those public policy issues where the Supreme Court has said that type of public policy judgment can't be used as a reason to deny or impair arbitration rights. And in fact, in Quackenbush from the Ninth Circuit, the liquidators tried to make an argument very similar to that one. And the Ninth Circuit said the district court had no discretion to consider public policy arguments in deciding whether to compel arbitration. And that aspect of Quackenbush came straight out of the U.S. Supreme Court precedent interpreting and applying the Federal Arbitration Act. Cases like Moses H. Cone and Allied Bruce, which talked about how a state cannot impose some sort of legislative or policy judgment that impairs an arbitration right.
Mr. Locher, let me tell you what bothers me about this case, and I'm not sure I can put a legal finger on it, but I can put a practical finger on it. The public has a tremendous interest in this proceeding. There were a lot of folks in Iowa that signed up for these policies. The company fizzled out very rapidly. It was a fiasco. I'm bothered by the provision that says the arbitration will be confidential, that nobody can talk about it, nothing can be revealed about it. Is there anything we as a court can do about that without unraveling the arbitration clause as a whole?
I don't know. I can say, and at the risk of repeating the point again, that even that type of policy judgment, no matter how well founded and how well intended, still can't override the mandate of the Federal Arbitration Act. So legally, that's where they are now.
The Arbitration Act doesn't say it has to be in secret.
That may be true, but I haven't studied the rules of the Commercial Arbitration Association to be able to say that with confidence.
If we say the claim is subject to arbitration and the liquidator has disavowed the contract, in arbitration, are the limitations in the contract still applicable if they can disavow the contract under the Iowa statute?
That would be a question that the arbitrator would have to decide. I think you'd still have the same problem there of trying to disavow a contract at the same time that you're bringing claims arising out of the contract. I don't think those two things can coexist, but ultimately that would be a question for an arbitrator to have to decide. It's not a question that this court has to decide here. Instead, the question for this court to decide is whether to follow all of these federal appellate courts and the courts in Nevada and Kentucky and Louisiana that have concluded specifically in the context of claims by liquidators against MilliMan, claims that in substance are identical to the claims that the liquidators here are bringing. The only difference is that the liquidators here chose not to use breach of contract as a label for one of those claims, whereas the liquidators in those other states did.
What do you make of the Ohio cases? The Taylor case in particular says the malpractice claim arises independently of the engagement letter. because it arises from the powers given from the liquidator, the General Assembly, et cetera, et cetera.
Two comments on that. First, the defendant in Taylor didn't even raise the Federal Arbitration Act as a basis for compelling arbitration. So right out of the gate, I think it's distinguishable. But let me get to your question. The Ohio Supreme Court, I think, made a decision to allow the plaintiff in that case to artfully plead around the Arbitration Act obligations. That was a split decision. If you look at the dissent in that case, the dissent really captures the essence of the U.S. Supreme Court case law and lower court following Supreme Court precedent in recognizing that you can't turn a breach of contract claim into tort or bring a statutory claim or do something like that to work around somebody's Arbitration Act rights. And that really gets to the heart of the purpose of the Federal Arbitration Act. Congress passed the act because lower courts and sometimes state courts were being too clever in trying to find ways not to enforce arbitration agreements. The United States Congress said you can't do that anymore. You've got to stop doing that.
Well, they haven't challenged the applicability of the Federal Arbitration Act, but I think the history suggests that it was only designed to allow enforceability of arbitration in federal court.
That's an interesting question, and I'm well aware of your dissent earlier this month. But the federal law is what it is, and that's what we'd ask the court to follow. And I know my time is up, so I'll be back for rebuttal. Thank you.
Ms. Byrd.
May it please the court, counsel. We've heard a lot about preemption this morning, but this case can and should be resolved on a straightforward issue of whether or not there's an enforceable contract under Iowa law. The agreement containing the arbitration clause is unenforceable because, among other reasons, the liquidator has disavowed the contract in its entirety as permitted under Iowa law.
That doesn't make any sense to me. All right, so let's say I cleaned the floors at Co-Opportunity, and when Co-Opportunity closed the doors, they owed me $100,000. And then you're saying the liquidator could just disavow the contract and there would be no debt? The debt would go away?
Yes, the liquidator may disavow the contract in carrying out his duties, but the employee would have a claim against the estate in the liquidation.
But that arising, well, or say I'm an independent contractor, arising out of the contract, though. In other words, the contract still is in effect. It's just like in bankruptcy. There would be the disavowal power is the power to say, I'm not going to perform that contract in the future. I'm not assuming it. We don't want that contract anymore. But the rights that were established under that contract still exist, right?
No, not as enforceable against the liquidator. The purpose of this statute is to allow the liquidator to disavow improvident contracts. Imagine a scenario where there's a horrible one-sided agreement. The liquidator, investigates and discovers egregious conduct giving rise to monumental damages. The liquidator absolutely has the ability to disavow the contract. Now, that doesn't preclude, in your scenario, the employee from asserting a claim in the liquidation estate, but the liquidator is not bound by the contract. That's what the legislature has granted in order to protect policyholders.
But let's say the contract provided that I was supposed to clean the floors so many days a week, and my company only did it fewer days a week. You could raise that as a defense, right? You could assert that argument. In other words, the contract doesn't just vanish, which is what you're saying, does it?
It doesn't vanish, but the liquidator is not bound by it. The claim on the estate would be for services provided to the company. That is what has happened in similar scenarios where there's been a disavowal of the contract. It doesn't preclude the creditor from coming in and saying, on a quantum merit basis, I provided these services and they're worth a certain amount.
Seems completely contrary to how, the analogous language, fairly similar language in the bankruptcy code or in FIREA works. It just doesn't make sense to me.
Well, the key distinction here is the bankruptcy code limits the disavowal authority to executory contracts. Here, the legislature could have done that. They could have added in that limitation of executory contracts or other limitations, but they did not. Under the plain language of the statute, the liquidator may affirm or disavow the improvident contract.
Under your theory of disavow, even if it went to arbitration, would you be able to disavow the damage limitations in the arbitration?
Yes, I mean, the liquidator's position is that he's not bound by any part of this contract. He's disavowed it in the entirety. And really the core issue here, the state court found 4 independent grounds under Iowa law that this contract was unenforceable. And an important aspect of this case is what is referred to as the savings clause under the FAA. Under that clause, arbitration is not required where the very contract containing the clause is unenforceable under neutral state law. I say neutral because in this case, the liquidation statutes that the liquidator has invoked don't target arbitration. They don't single out arbitration. There's no hostility towards arbitration. They're completely neutral. And the body of case law on FAA preemption holds from this court and the United States Supreme Court that state law is only preempted by the FAA when it has a hostility towards arbitration, when it singles out for arbitration differently from other contracts. So
could you speak to reverse preemption? We're in the insurance context, but most of the definitions I've seen of the business of insurance seem to focus on the policyholder-insurer relationship, not a broader, unwinding of an insurance company that's insolvent that could apply to any variety of businesses. So do you have authority that the business of insurance for reverse preemption purposes includes this scenario?
Yes, I think the key case on this is United States Treasury versus FABE. This is a United States Supreme Court decision where the court holds that Ohio state statute granting priority to policyholders above all other creditors reverse preempted the federal law of general application.
Again, we're talking policyholder rights, and these claims seem more directed at recovery from the actuarial services for malpractice, not a policyholder who didn't receive the insurance benefits promised.
But this action is integral to enforcement of the policyholder contract. The liquidator is tasked with marshaling the assets of the state, maximizing them, and bringing claims on behalf of policyholders and creditors to recover for the state. And that's exactly what's happening here. The claims here, the liquidator is using his express authority granted by the legislature to bring policyholder claims to benefit policyholders and to ensure enforcement of their contract. And that's exactly what the Supreme Court focused on. The aim of the Ohio statute was to enforce policyholder contracts.
Can you recover as effectively in the arbitration forum as you could in Polk County District Court? And if not, how are you handicapped?
We would be handicapped if sent to arbitration because, first of all, under the Iowa law, this is supposed to be a transparent proceeding. We're bringing claims on behalf of policyholders who, in the world of confidential arbitration, would have no insight into the whole process. Second of all, and it goes back to my original point here, this case can and should be resolved without any preemption problem under the FAA. There's only a preemption problem if Iowa law is hostile to arbitration. In Heberlin, this court held that an Iowa statute that targeted arbitration in the context of adhesion contracts was preempted by the FAA. Same with a whole body of United States Supreme Court case law. In fact, in one of the cases that MilliMan relies upon, Castle-Roto case, it's Doctors Associates versus Castle-Roto, the United States Supreme Court held Montana's first page notice requirement, which governs not any contract, but specifically and solely contracts subject to arbitration, conflicts with the FAA, and is therefore displaced by the federal measure. The Supreme Court held that generally applicable contract offenses, such as but not limited to fraud, duress, so on and so forth, may be applied to invalidate agreements without contravening the FAA.
I'm not sure I got a complete answer to my earlier question. You mentioned transparency, and I accept that as a vital public interest in this context. Is there any other shortcoming in the arbitration forum that would handicap the liquidator's ability to perform its function here?
Absolutely. It's the liquidator's ability to bring claims on behalf of policyholders and creditors who are certainly not bound by the arbitration agreement.
But aren't you stepping
About
into
that.
the shoes of the insurance company here?
No, not in this case for two reasons. We have disavowed the entire contract. We do not stand in the shoes of this company as it relates to the contract. And second, we're not a mere successor to this company. We have a unique public protection rule that the Iowa legislature has granted to bring policyholder and creditor claims. And
But all the money that you collect is going to go into the estate. You're not going to be MilliMan is not going to be paying money directly to policyholders, right? So you're not really litigating on their behalf. You're litigating for the liquidation estate, and then if you get enough money, you'll make distributions, right?
But importantly, in the liquidation estate, just like Ohio, policyholders have the very highest priority, okay? So the claims on behalf of the policyholders and creditors, if there's a recovery in this action, would inure to the benefit because it would ensure, above all other creditors, enforcement of their contracts. I also want to address some of the broad brushstrokes about what this case law...
Before you go there, is the liquidator acting as a successor to the company or more as the enforcement arm of the insurance commissioner?
The enforcement arm of the insurance commissioner. The claims here arise because there were representations by MilliMan about the financial condition of this company. Those representations went not just to the company, but to the regulators who are charged with trying to ascertain the financial condition of the company on behalf of policyholders and the public.
Would we be here today if the insurance commissioner brought this action? I mean, can they force the insurance commissioner into arbitration?
I don't think so. I also want to address the broad brush case law characterizations made by MilliMan in this case. MilliMan would have this court believe that there is a body of precedent, well-established federal case law directly on point. But what's happening is MilliMan is cherry-picking cases from across the nation where the liquidator has assumed the contract. He's elected the contract and sued to enforce the very contract containing the arbitration clauses. When you look at each and every one of the cases that MilliMan's counsel just rattled off to you in its presentation, those cases involve an action to enforce the contract containing the arbitration clauses.
Well, why don't you address the argument that he raised when I was questioning him, and that is this, to paraphrase, I mean, the services rendered by MilliMan were rendered pursuant to the contract, and I think but for the contract, he states, and seems kind of likely to me, but for the contract, MilliMan would not have provided the services. If that is true, aren't you, kind of playing a game of labels? But for the contract, the services wouldn't have been rendered, and can you claim that this is an independent, somehow independent from that when you're really locked in on a cause and fact theory?
No court has applied a but-for test in determining whether to hold a liquidator to an insurer's contract. In fact, in each of the cases so Iowa has a particularly robust code, but it's not unique. There are other states that have enacted disavowal statutes. And in each and every one of those cases, the liquidator disavowed an improvident contract and then sued and brought tort claims. And the courts held that that disavowal was an arbitration-neutral state law grounds on which the very contract was unenforceable, therefore entirely consistent with the FAA. The FAA doesn't elevate for special treatment arbitration agreements. It merely puts them on equal footing. So under all of those cases, Benjamin versus Pipley, Covington versus Locher, State X. Rel. Wagner versus Kay, the liquidator disavows, it's unenforceable under state law, matter closed. On that threshold issue, without any conflict or preemption problem, the contract is unenforceable. And in each of those cases, importantly, the argument could have been made that but for the directors and officers contract, with the defunct insurer, the liquidator would not have claims. But that is not the standard that courts have applied in determining whether or not a statutory liquidator is bound. And in fact, there is no case where a liquidator has disavowed a contract, as in this case, and arbitration has nonetheless been required under the FAA. And there's not a single case where a liquidator has asserted the claims such as the ones here on behalf of policyholders and creditors for tort only, where the court has nonetheless required arbitration. MilliMan is asking this court to do something that no other court in the nation has done with the sorts of claims presented here. This case should be resolved on a straightforward threshold question. This court emphasized the importance of that question in the Rent-A-Center case. Before we get into preemption and differing policy goals, is there an enforceable contract? And in this case, the answer to that is no. Unless the court has any other questions, I've concluded my presentation.
Your argument rests on this interpretation of disavowal, right?
Well, the district court found 4 independent state law grounds on which this contract was not binding on the liquidator. Certainly, disavowal is among them. But second, he's a non-signatory. Third, he's not a mere successor who stands in the shoes of the company in relation to this claim. So even if this court accepts disavowal, there are other state law grounds on which this contract is unenforceable. And even under the FAA, arbitration should therefore not be compelled.
Thank you very much.
Thank you.
Is there any rebuttal?
Yes, Your Honor. May it please the court.
Mr. Locher, before you start, in reading the statutes, 507C18 appoints the insurance commissioner as liquidator to enforce this act, and then he can or she can appoint a special deputy, which is in this case, and they're actually the parties to this case. How is this case any different from a Rent-A-Center case where the Civil Rights Commission was enforcing a remedy? Because here, really, the insurance commissioner is enforcing a remedy, not a successor in interest to this contract.
The insurance commissioner doesn't have any independent statutory authority under the Liquidation Act to bring his own claims against a third party like MilliMan for damages. Instead, any claim that he wants to bring for damages has to be derivative of someone else's claims, in this case, co-opportunity, which means he's subject to co-opportunity's obligations.
Rent-A-Center, the claim was derivative of the employee who was discriminated against.
It wasn't, though. If you read the case closely, Rent-A-Center came down to the fact that the ICRC had its own independent statutory authority to bring claims. In fact, the ICRC could bring claims even if the employee didn't want to pursue a claim, or even if the employee had already settled it. And that was the crux of the decision in ICRC. The analogy here is to Roth. The administrator in Roth had an obligation to look out for the interests of beneficiaries and creditors of the estate and that sort of thing. Even so, when the administrator was bringing claims that belonged to the decedent of the estate who had signed an arbitration agreement, the administrator was subject to that same arbitration obligation. The liquidators here are on exactly the same footing. I point out further to that end that the liquidator would have no claims here but for claims belonging to co-opportunity, and we know that because they admit the recovery is going to go to the estate, and they haven't identified any statutory provision that gives them their own independent claims akin to what the Iowa Civil Rights Commission had in Rent-A-Center. I also want to talk about the disavowal statute. What the liquidators are arguing here is that when the Iowa legislature enacted the disavowal statute, the legislature intentionally wanted liquidators to have the ability, in the context of an already completed contract, to dictate where and how disputes under that contract were going to be litigated. If that's really what the Iowa legislature had in mind with the disavowal statute, and we very much disagree with that reading, but even if that is what they had in mind, that statute, as applied here, would be preempted by the Federal Arbitration Act. It doesn't matter on its face that it's neutral, because as applied, they're targeting arbitration provisions and similar forum selection provisions for unfavorable treatment.
No, I have trouble with that. The non-avowal provision in the code is general in nature. There are all kinds of contracts that can be disavowed by the commissioner. I mean, I think it's an extraordinary provision. I mean, that's my Jolly Green Giant, analogy. But it's not limited to arbitrability. Now, if you disavow the contract, you got to disavow the entire contract, and you've made that point in your brief, and I think that's absolutely right. You can't cherry pick the contract. But the provision itself covers thousands of contracts that might be out there. The insurance commissioner or his deputy could disavow a cleaning contract, could disavow a contract with an officer for excessive compensation. We could come up with 1,000. It seems to me it's not targeted arbitration at all. And indeed, what you're suggesting is that federal law requires an exception to the broadly stated disavowal provision.
Look at AT&T Mobility versus Concepcion. The California Supreme Court in that case took the doctrine of unconscionability, which is generally applicable, and they tried to apply it in a targeted way to disfavor or impair somebody's arbitration rights. The U.S. Supreme Court said, no, you can't do that. That violates the FAA. In Southland Corp versus Keating, California passed a franchise investment law that said neutrally, if any provision of a franchise agreement is inconsistent with this law, it's void. The U.S. Supreme Court said as soon as you apply that facially neutral statute to impair somebody's arbitration rights, it's void. The same principle applies here. If the disavowal power really is as broad and as elastic and maneuverable as the liquidators claim it is, then the Iowa legislature intended to impair arbitration rights in a way that the FAA would prohibit. And that's why the FAA case law governs. Thank you very much.
Thank you very much. The case is deemed submitted, and you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.